Incident. Involvement in the criminal justice system begins with an alleged violation of state criminal law, or local or municipal ordinance. Individuals can enter police custody in different ways. A police officer may directly observe a violation of the law or ordinance, or may be called to investigate a report of a possible crime. In either case, when a police officer determines that he or she has probable cause to believe an individual committed a criminal act, he or she can take that person into custody. Even with probable cause, a police officer may choose to release the individual and continue an investigation into the alleged offense. A police officer has discretion, limited by the police department's policy, regarding what action he or she takes. A person also may be taken into police custody on a warrant. A warrant is an order issued by a judge authorizing the arrest of a specific person. Figure 3 provides some of the rights of individuals accused of a crime, but is not exhaustive. Complaint. A complaint is a document completed by a police officer stating the alleged offense. The complaint informs the accused of the nature of the charge, and its filing starts the court process. Figure 3. Rights of the accused. The following are some rights of adults accused of a crime. Right to remain silent at every step of the investigation and criminal prosecution. Right to prompt bond hearing. Right to a free attorney if the individual cannot afford to hire a private attorney, as determined by the court. Right to decide whether to plead guilty or not guilty. Right to be informed of the evidence and witness statements in the prosecution's possession. Right to decide whether to present the case to a jury or judge for trial. Right to confront witnesses. Right to testify or not testify during criminal proceedings. Right to appeal a conviction. Right to refuse to provide DNA samples except when ordered by the court. Complaint. A complaint is a document completed by a police officer stating the alleged offense. The complaint informs the accused of the nature of the charge, and its filing starts the court process.
Warrants. Arrest warrants may be issued in a variety of situations. An arrest warrant may be issued upon complaint when a complaint is presented to a court charging that an offense has been committed, and the court determines through examination of the complaint that there is probable cause to believe the person committed the offense. 725 ILCS 5/107-9. An arrest warrant also may be issued when a person fails to comply with the conditions of a court order, such as failing to appear in court. 725 ILCS 5/110-3, or violating an order of protection in a domestic violence case. Initial police stop. A police officer can stop any person in a public place for a reasonable amount of time when the officer has a reasonable suspicion based on specific facts that an individual is committing, is about to commit, or has committed an offense. The officer may ask the name and address of the individual and may ask questions about the individual's actions or reason for being in the area. 725 ILCS 5/107-14. While an officer may question citizens during such stops, citizens have a right to remain silent. If the officer has specific reason to believe that the individual may be armed, the officer also has the right to pat down the individual for weapons. The permissible period of detention must be reasonably brief. If the officer's suspicions are not confirmed by the contact, the individual is free to go. Arrest. If the officer has probable cause to believe that an individual has committed an offense, the officer may make an arrest. Once taken into police custody and placed under arrest, an individual must be informed of certain constitutional, Miranda, rights prior to questioning by police. Among these is that an individual has the right to remain silent and the right to an attorney. If a person is not advised of his or her Miranda rights prior to interrogation, the person may be able To prevent prosecutors from using the results of the interrogation in a subsequent criminal trial. When an arrest is made, an arrest card is completed either electronically or on paper that includes the individual's fingerprints, offenses with which they are being charged, their race, gender, age, and other information. The information is then submitted to the Illinois State Police's Criminal History Records Information (CRI) system. Appendix A includes a copy of an arrest card used by police in Illinois. Options available to officers at the time of an arrest include releasing the individual without criminal charges, releasing the individual with a request to the state's attorney, or prosecutor, to review the case to file charges, or formally charging the suspect. If formally charged, a person has the right to know the nature of the offense on which the charge is based. Charges. After a case is investigated by the police, they make the initial decision of whether probable cause exists to charge an arrestee with a crime. Probable cause is a police officer's reasonable
belief that a violation of state law occurred. The police officer's initial decision will be re-evaluated by a court. Police investigations include interviewing witnesses and gathering physical evidence. Witnesses interviewed may include victims, suspects, possible eyewitnesses, and expert witnesses. If the police decide not to file charges due to insufficient evidence or for any other reason, the arrestee is released from custody. Charges may be filed later. However, for most crimes, charges must be filed within a specific time period, due to the statutes of limitation. Time limits differ depending on whether the crime is a misdemeanor or a felony. Misdemeanor crimes carry a possible jail sentence of less than 1 year. Felony crimes carry a possible sentence to incarceration of 1 year or more in the state prison. Generally, statutes of limitation are 18 months for misdemeanors and 3 years for felonies. However, there are some exceptions. 720 ILCS 5/3-5. When the police are seeking felony charges, the prosecutor is usually contacted to review the charges. Prosecutors are usually available around the clock to screen cases for felony charges. They can approve felony charges, decline felony charges, or instruct the police to continue the investigation. The suspect may be held in custody for a reasonable period of time as an investigation continues. After further investigation, the police may again contact a prosecutor for approval of felony charges. If felony charges are not approved, police have the option of charging the suspect with a misdemeanor offense, if appropriate.